Shannon, if you can quickly introduce yourself and tell me a little bit about your background in criminal defense.
Yes, ma'am. My name's Shannon Locke. I'm a board certified criminal defense attorney. I am practicing in San Antonio, Texas, and a managing partner of the Locke Law Group.
In reading this fact pattern of what police say transpired, what are some things that stand out to you as far as this goes in terms of it being a either lawful or unlawful use of deadly force against this individual who allegedly trespassed on this man's property?
Sure. So first off, what I'd like to say is that you don't really know what happens. Reading police reports and just getting an overview like this, it's hard to say exactly what happened. And as a criminal defense attorney, what I would be looking for is framing the issues and which issues we could frame to get our client the best possible result. And so here, obviously, there are a couple of different issues. One is whether or not he was defending his property, whether or not he was justified in using deadly force to defend his property, and whether or not there's a possible self-defense claim. And so as I look at the hierarchy of issues, number one, when you shoot someone or use a firearm, you're automatically using deadly force. That isn't anything else. In Texas, there is a pretty strong presumption that if you're going to use a firearm, you're using deadly force. So you can't really argue that he wasn't using deadly force. According to the police reports, the shot was to the chest. There's just not going to be a strong argument that this wasn't deadly force. So when it's deadly force, you have to ask yourself, okay, so what do you have to do to justify deadly force? Okay, and so that's found in Penal Code 9.42, and it basically says a person is justified in using deadly force against another to protect land or tangible movable property. If you'd be justified in using force under the section that allows you to use any kind of force, and that's basically, look, if somebody is trespassing, but okay, so if somebody's trespassing, you can use force, but to get it to be deadly force, what you have to have is you have to have uh, it has to be immediately necessary to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, okay, theft during the nighttime, or criminal mischief during the nighttime. All right. So those are going to be the questions and so is it the nighttime is a question. Was there criminal mischief going on is a question. Could there be theft going on? Imminent commission of theft. All right, that might be an argument that you could make. Um, and it was early morning hours. Is that the nighttime? And so those are all kinds of questions that you can ask as a criminal defense attorney moving forward to determine whether or not this was a lawful use of deadly force.
Something that we've seen a lot of in the comments were this conflict between he was in the right. You have a right to protect your property in the state of Texas. And I mean, even on these social media apps for neighborhoods, you have people make comments to the effect of somebody comes to my door, they're going to get X, Y, or Z. Um,
Yes.
when you see these kinds of comments, what are the first things that go through your mind as a criminal defense attorney?
So I think what I think of is that if you're going to shoot somebody, you have to be willing to go to jail. Okay, it has to be so necessary that you're going to be willing to go to jail. The way that these defenses work is that if and frankly, if somebody's in my house at night and I have to choose between shooting them or going to jail, frankly, I would rather go to jail than to see what happens next. I'm not gonna tolerate that, and so that's when it's immediately necessary. And so you have to be prepared. If you're sitting there saying, well, should I do it or shouldn't I? Then it's probably not immediately necessary. So it has to be immediately necessary to prevent a greater harm. And that's and frankly there's not a lot of calculation that can go on there. It has to be an immediate uh, almost instinctual use of force for it to be justified. So people have to be very careful about this. And if you're sitting there and you're somebody knocks on your door and you don't know who they are, then and you do end up using deadly force against them, And at the end of the day, you have to look back and say, okay, was that worth it? Uh, was it really worth it? Is kind of the question that you have to ask yourself. Typically, the reason I think there's such a misconception is that the burglary part of this is such a common. Somebody comes outside, they see somebody burglarizing their vehicle, and then they can use deadly force in those circumstances. And in fact, if somebody's burglarizing your vehicle and multiple people, and one of them dies in the commission of the burglary, the other person could actually maybe charged with murder. So I think those sorts of stories get into the community conversation, and it then becomes, well, if they're burglarizing my vehicle, why can't I use deadly force to get them off my land? But if it's not immediately necessary, then you can't, and you risk the whole trial and tribulation of going to jail, bonding out, getting a lawyer, going through the justice system as they try to figure out whether or not this force was immediately necessary or not.
Somebody had said something to the effect of, well, he had to be in her home. I'm sorry, she had to be in his home in order for him to use deadly force. Talk to me about some of these, I guess, misconceptions or theories that it would be lawful under X, Y, or Z. Just had this one thing occurred,
Right.
it would be lawful.
And so, certainly if she had entered his home, then yes, that would be. And again, what you're looking at is, and we don't know, really, because we don't know if he thought she was committing theft. Because remember, it's the imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. So those are all questions that that frankly uh, we don't know yet. We don't know the answers to those yet, and really a criminal defense attorney is going to dig into that and sort of see, is that the appropriate issue? How far apart were these people when this happened? If you tell somebody to get off your property and they continue towards you, if there's something in their hand or something like that, you can use then self. You might be able to use self-defense to prevent the other person from using deadly force against you, if that's the calculus. So there's a lot here that we don't know. As a criminal defense attorney, if I were to get this case, I would begin looking at the hierarchy of issues to determine whether or not, okay, was this self-defense? Was this defense of property? Uh, was the deadly force justified? All of those issues to begin sorting through whether or not this was a justified act or an aggravated assault.
And ultimately, I guess your your big takeaway from things like this. I know you had said some stories just get implanted into people's brains of, oh, I remember so and so did this and it was fine, but just the big takeaway from situations like this.
So I think you need to be very careful using deadly force, and it really needs to be immediately necessary. That's kind of the big takeaway here is that if the police find that you have shot somebody, okay, they're probably going to take you to jail, and it's not something that you can really sit there and strategize about. It has to be almost an instinctual, okay, if I don't do this, then something worse is going to happen. Uh, and so uh, it can't be strategic. It has to be instinctual. It has to be immediately necessary, and there has to be a greater harm that's going to occur shortly. And so these things are all very undefined. And they're undefined because what ends up happening is you end up going through the criminal justice system, and this person who is probably, we're going to have, whoever is representing him, and he will probably end up experiencing a jury trial in about 2 years. And during that time, he has to be on bond. If he is bonded out, he has to be represented by counsel. And all of these questions about whether or not it's immediately necessary, how far apart they were, what she was going to do next, what he thought she was going to do next. And it's also very important when you're in these circumstances to really invoke your right to remain silent, because all of these things are better left discussed with your lawyer than over a jail call or to the police because you don't understand all of the intricacies of the law, all of the different moving parts. Uh, for instance, if you're intoxicated, it may be difficult to use a deadly force instruction or a deadly force defense. So all of these little intricacies play into whether or not you can do this, and doing it lightly is almost always a mistake. So you really have to appreciate that even though we're in Texas, even though we have a strong defensive property statute, that you can't take these things lightly, and you have to think about it, or you have to be immediately in need of doing what you have to do to protect yourself and your property.
And last question for me, what should you do if you've got somebody that has now entered your property, you've asked them to leave, you've informed them that you're armed, what
So
should you do?
yeah, let's look at the statute and what the statute says. And if you read it, it's one, okay, and it has that list that I've read about the nighttime criminal mischief, the nighttime theft, the aggravated robbery, the robbery, burglary, all that stuff. And then it also says he reasonably believes that the property or land cannot be protected or recovered by any other means, okay? So you have no other options available to you. Okay, the use of force other than deadly force to protect or recover would be expose the actor to another to a substantial risk of death or serious bodily injury. Okay, so that's a pretty high standard. Okay, that's a tough standard. So you have to sit there and say, okay, this person knocking on my door. Okay, uh, I have to use this force, or else they're going to, so you have to be able to credibly make that argument to get that kind of instruction. So to sort of play this out for you, the way that it works is police find somebody is shot, they're going to take someone to jail. They're going to find the person that shot them, and that's probable cause, and they're going to take you to jail, unless the use of that force is clearly justified. They're gonna default to taking you to jail. They'll take you to jail, and then, as you go through the criminal justice system, what's going to end up happening is the jury's going to get that instruction, and that is your remedy. Okay, it's you could go to the DA's office and say, look, he was justified. He was justified, but the DA's office is probably just going to say, well, let's let a jury sort this out, and so the jury's going to apply that standard, and so your benefit to using this force is that you get that instruction if the judge feels that it's appropriate to give. And then the jury has to decide, okay, was there nothing else that he could do other than use this deadly force? And that's a little different than self-defense, which is the kind of the other avenue that I would be exploring here, which would be self-defense, because you can use deadly force and you don't have to retreat for deadly force, but may have to retreat for deadly force and defensive property. So it's very intricate. It's not clear cut, and that's why you have to be absolutely certain that you have to do this immediately to prevent something worse happening to you.
I appreciate that
Sure.
explanation.
Yeah.
It's not clear. It's definitely not clear. And clearly from these comments, I think that the public would agree that it's not very clear. Is there anything else that you'd like to add that I didn't ask?
Well, yeah. So as the criminal defense attorney, what I'd probably be doing is I would say that the better affirmative defense here might be self-defense. Uh, But so what people need to understand, I think, is that the criminal justice system at the beginning is very quick to take you to jail. Okay, so the police are going to be very quick to take you to jail. They're not going to sit there and say, okay, was this immediately necessary? Or, if they find somebody that was shot, they are and they know who did it, and that person is there. They're going to take that person to jail. And then they're going to let the DA's office and the criminal defense attorneys and all that. And that can be a costly, slow process that can, and if you were about to die, then it's worth it, right? But if you weren't, then it really isn't. And so, as you're making these, as you're in these circumstances, uh, the remedy is a jury trial. and that can be a lengthy and costly process. And people need to be aware of that. That it's not just that police officers, when they find somebody that's been shot, aren't going to sit there and try to look from the other person's perspective and try to cut them some slack. They're going to make an arrest decision, and they're going to, in my experience, they're going to make an arrest unless it's completely clear cut that this was justified force.
And do you ever see any cases where it is completely clear cut where
I mean, I do. So if somebody is in your house, okay, uh, then 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 that's going to be then that's going to be clearly justified force. Okay, if somebody is in your vehicle stealing your things, and you use force like that, then that's going to be clearly justified. Uh, but if other than that, it's going to be difficult.